So as we've traced the chronological history of our country from its founding through the civil rights movement of the mid-20th century, we have seen repeated examples of concerted efforts to suppress the voting power of non-white people. Today, we will focus explicitly on the right to vote as the foundation of our democracy and the extraordinary efforts that have been expended and are intensifying to this day to prevent these citizens from achieving meaningful representation. So let's continue. We'll start, as we do, with a brief recap of last week's class, where we looked at the criminal justice system in America, specifically mass incarceration and the war on drugs, and the pivotal time periods of 1971, Richard Nixon, 1982, Ronald Reagan, as was 1986, and 1994, President Bill Clinton. We saw how law enforcement incentives were applied to prioritize drug law enforcement. The huge dollars that were available for law enforcement as a consequence of things like civil asset sharing that led to the militarization of our state and local law enforcement agencies. We know that we describe this as mass incarceration because the United States leads the world in incarcerating our citizens. We are less than 5% of the world's population, and we have 25% of the world's prisoners. The laws that were written and the way in which they are enforced has created a disproportionate impact on people of color. And today, our criminal justice system is racialized at every stage. And then we have the videos that we have seen of individual police officers' use of violence with impunity, reminiscent of the stages of our history when lynching was a key tool used to keep Black people in line. So today, we are going to look at voting in the United States, the role it plays, the importance it carries, and the efforts being made to try to narrow the population that is able to have their voices heard through their vote. So we'll begin with a historical framework of voting rights for our country. We will take some time to look at the path to representation for African Americans after the Civil War. And as we have come to expect, as progress is made, the backlash, the adaptive tactics that have been employed to try to undo some of the progress that's been achieved. And indeed, in the case of voting rights, those adaptive tactics by the white majority have been in place for nearly 100 years. We'll look at the Voting Rights Act of 1965, a really pivotal piece of our country's legislative progress, and then the various phases of the ongoing assault. So, our historical framework. We begin with the words of Thomas Jefferson in the Declaration of Independence, where he writes, "Governments are instituted among men." I'm sure he meant to say women. It probably didn't have enough ink in his quill pen, never mind. Governments are instituted among men, deriving their just powers from the consent of the governed. So the power that governments wield is granted them by the consent of the people that they govern. That is fundamental to our form of government. In terms of the United States Constitution, there is only one clause that refers to voting in all of the Constitution. It is Article 1, Section 4, Clause 1, and it reads, "The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But Congress may at any time make or alter such regulations, except as to the place of choosing senators." Kind of a strange clause. That's it. That's all the original Constitution has to say about voting. But when we look at the set of constitutional amendments, we come to see that once we get beyond the Bill of Rights, the first 10 amendments to the Constitution, almost 1/3 of the amendments made to the Constitution have something to do with voting. So we may not have said much to start, but we've said a lot as time goes on. So the first of the constitutional amendments was the 14th Amendment, which was put into place in 1868, and it explicitly granted citizenship to those who had been enslaved. Indeed, we're paying a lot of attention to the 14th Amendment today because what it says is that anyone born in the United States is a citizen of the United States. And it also indicates that every citizen in the US is entitled to due process, which goes directly against what the Dred Scott case by the Supreme Court. That decision denied due process to African Americans. The 14th Amendment asserts that it belongs to all. The 15th Amendment was written by Congress because in that 1868, the period after 1868, the violence against African Americans seeking to vote led Congress to conclude that while they thought that declaring that African Americans were citizens would be sufficient to ensure their right to vote, that wasn't the way it was working out. And so the 15th Amendment in 1870 said that the right to vote shall not be denied based on race, color, or condition of previous servitude. We fast forward 50 years to the passage of the 19th Amendment, which granted women the right to vote. But it's important to understand that continuing backlash against African Americans meant that very few African American women were granted the right to vote by the 19th Amendment. The 23rd Amendment gave the District of Columbia the ability to vote for the president and vice president. Residents of the district have no representation in Congress, no senator, no representative. And up until 1961, they could not even cast a vote for president or vice president. And that was corrected with the 23rd Amendment. 3 years later, the 24th Amendment was ratified. It outlawed poll taxes. Now, in reality, poll taxes had been outlawed decades before, but they continued to be applied to African Americans seeking to vote. And so Congress determined that a simple law that said poll taxes were outlawed was insufficient, and that indeed a constitutional amendment was required. I will say that the passage of that amendment did not end the use of poll taxes, but it did severely limit them and led to them being nearly eliminated. And we'll talk a little bit more about that a little later on. And the final constitutional amendment dealing with voting was the 26th Amendment in 1971 that reduced the voting age from 21 to 18. That was during the period of the Vietnam War, when there was a nationwide military draft. And the sentiment in the country was, if an 18-year-old person can be drafted and sent to fight and die for his or her country, then he or she should surely have the right to vote, to elect the people who would be making those decisions. So that's our framework. A side note I bring up is the Snyder Act of 1924. It's relatively little known. Perhaps some of you have heard of it. I had not. But the Snyder Act of 1924 granted citizenship to Native Americans, the people who were here first. Up until that point in time, Native Americans were not considered citizens of the United States, were not protected by the Constitution and constitutional amendments describing citizenship rights. And so the Snyder Act ostensibly took care of that. But because states have the ability to draft and implement laws about voting, most states continued to prevent Native Americans voting despite the passage of the Snyder Act until 1957, when the last of the Native Americans did indeed receive their right to vote. And then the most significant action regarding voting in the United States is the Voting Rights Act of 1965. And it was enacted to enforce the 15th Amendment, which was enacted to enforce the 14th Amendment. And so we keep seeing all of this pushback that requires more and more legal infrastructure simply to guarantee African Americans the right to vote. So the path to representation began, of course, in 1865, when the slaves were freed, sort of. And we saw how that loophole was used to enable the creation of convict leasing, public chain gangs, and even today, employment of incarcerated people where payment for their labor remands to the state or to the Department of Corrections, not to the workers themselves. The 14th Amendment that granted citizenship and due process to African Americans. After the Civil War, the states who were requesting readmission to the Union had to ratify the 14th Amendment, or they could not be readmitted to the United States. So many of them ratified it, but did not act in concert with its provisions. And of course, in 1870, the right to vote. That year, more than 500,000 Black men registered to vote, and participation in the election that year was more than 90%. And you may have seen statistics about voting turnout in the United States these days, and it's pretty abysmal, the numbers of people who actually act to exercise their right to vote, their ability to give their consent to be governed. And so, ostensibly, this meant representation at last. That year in 1870, with that large Black voting turnout, more than 600 state legislators who were elected were Black, 18 state executives. The governor of Louisiana was a Black man elected that year, the last time that would happen until 1960. And there were 18 US congressmen and 2 US senators elected who were African American. And these integrated legislatures began working to craft laws on finance, on charitable and penal institutions, on public schools. There was, that was part of the ray of hope during Reconstruction, was seeing integrated legislative bodies working together for the good of all. But the adaptive tactics began immediately, and most specifically with violence as voter suppression. In 1865, the Ku Klux Klan was formed in Pulaski, Tennessee. 2 years later, the Knights of the White Camellia, as another anti-Black organization, was created. And those two were private organizations. People did not, there's not a list of names in the newspaper of who belonged to the KKK or the Knights of the White Camellia. You could be a member of those groups and your identity would not be revealed. But in 1874, the White League was formed, and in 1875, the Red Shirts. And those were public groups where the names of those who were members of those violent anti-Black organizations were proudly a matter of public record. And so we saw that shift occurring. You may remember this graphic from our second class, where the lynchings occurred during Reconstruction, those 12 years of Reconstruction. And we're going to look specifically at where they were directed at disenfranchising Black voters. In Camilla, Georgia, in 1868, white mobs attacked Black residents who had gathered to protest efforts to keep them from voting, killed at least 7 Black people. That same year in McDuffie County, Georgia, a Black man named Daniel Blue a Black man named Perry Jeffries, his wife, and 4 of their sons were attacked and lynched by a white mob that targeted Mr. McDuffie for voting. Because he voted, they killed his family. We all know about Colfax, Louisiana, where at least 150 Black people were killed, with a message being, this is what happens to you if you try to exercise your right to vote. In Clinton, Mississippi, in September of 1875, armed white mobs attacked the Black community after a political meeting. As people were leaving the political gathering, the white mob killed about 50 Black people. And in 1876, in Hamburg, South Carolina, in violence leading up to Election Day to keep people from casting a vote, the white mob attacked Black men who were stationed at the National Guard Armory and killed at least 6 of them. And so much of the violence that was being exercised during this time period was focused on sending the message that there is danger if Black people seek to cast their right to vote. We know about the 1876 election and the fact that a compromise or a committee was formed to make a decision between the election of Samuel J. Tilden, governor of New York, and Rutherford B. Hayes, governor of Ohio. And the 8-person Republican, 7-person Democratic group voted to name Rutherford B. Hayes as president of the United States if he would promise to end Reconstruction. And he did, and they did. And the troops were withdrawn from the 10 southern states that had been in rebellion against the Union. In 1890, the state of Mississippi called a constitutional convention with the goal of ending Black voting once and for all. The new Constitution required that in order to register, potential voters had to be Mississippi residents for 2 years, pay an annual poll tax, and pass an elaborate literacy test. The understanding and interpretation test was meant not only to prevent new registration by Mississippi's extensive African American population, but also to disqualify those people who were already on the voting rolls. Whites were given simple clauses to read, and again, they were often assisted by the white poll workers, while African Americans were given serpentine, incomprehensible clauses, which had been inserted into the Mississippi Constitution specifically for the purpose of preventing the African American voter registration candidate from being able to explain it because it intentionally made no sense. One of the framers said the poll tax won't keep them from voting. What keeps them from voting is Section 244 of the Constitution of 1890 that Senator George wrote. It says that for a man to register, he must be able to read and explain the Constitution. And then Senator George wrote a constitution that damn few white men and no N-words at all can explain. And so almost 123,000 African American voters were disenfranchised overnight. And by 1904, there were only 1,300 registered Black voters in the state of Mississippi. Every southern state followed suit. In addition to the poll tax and the literacy test was the grandfather clause. And the grandfather clause said that if your grandfather was eligible to vote prior to 1865, then you are eligible to vote. Of course, no African American was eligible to vote prior to that date. And so it excluded African Americans on that basis. And so the impact on registration overall is that Black participation in elections in 1870 went from 90% to less than 6% in 1892. And one of the really interesting aspects of the Mississippi Plan only came to light in an article I read just before Election Day in 2023. Because one of the clauses in the Mississippi Plan said that if you were to run for a statewide office, governor, any one of the administrative offices, the only way you could be elected is if you got both a majority of the total vote and a majority of the votes of every district in the state. And because African Americans had been pushed into a small number of districts, even if their numbers were sufficient for the candidate to receive the most votes, there was no way that that person was going to receive the majority votes in most of the districts. And that law was still in effect in 2023, which may explain why there were no African Americans elected to statewide office in Mississippi. Sorry. The Louisiana Constitution had similar goals. It intended to establish the supremacy of the white race. It was the stated intention of that constitutional convention. And it had the same result in dramatically decreasing the number of African Americans who were eligible to vote. And so by 1910, in essence, no Southern Black people could vote, none. And through some heroic efforts at modifying some voter rights laws, by 1940, 3% of the total population of African Americans in the southern states were registered to vote. And so that began to show that there were Black people who were going to be able to cast a vote, and that was sort of terrifying to the white political parties. And so in 1921, parties began instituting white primaries. What that was, it was a virtual one-party system in the South. In all but a few areas, if you were the Democratic Party nominee, you were going to win the election. And often Republicans didn't even bother to field a candidate. And despite the overwhelming numbers, the Democratic Party in many states adopted a rule that excluded them from party membership. You're not a member of the party, so you can't vote in the primaries. And the Supreme Court was asked to weigh in on that, saying it doesn't seem fair, it doesn't seem constitutional that a party could deny membership to someone because of their race. And the Supreme Court, in its wisdom in Newbury v. United States, ruled that political parties were private organizations and not part of the government election apparatus. And so it was perfectly fine for the political parties to deny African Americans membership in the party and an ability to vote in a primary. That was overturned in Smith v. Allwright in 1944, and it struck down the white primaries as a violation of the 15th Amendment's prohibition against voting discrimination based on race. And so once the Supreme Court made that decision, then Texas Democrats created a private organization from which African Americans were excluded. And the members of that association held pre-primary elections to select the candidates for the integrated Democratic primaries. And it took until 1953 for the Supreme Court to say, no, that's unconstitutional as well. 1953. The adaptive tactics continued with intimidation, not the wide-scale lynchings that we had seen in other parts of the country's past, but here is an editorial cartoon in the Miami Herald in 1940, just to make clear that there might be some risk if you're an African American and you choose to express your right to vote. Economic factors played in as well, as states began evicting sharecroppers if they tried to register or tried to vote. And an evicted sharecropper typically had nowhere to go. It wasn't like they had family members who owned property and had their own farms or businesses. And so the white power structure knew that either eviction or the threat of eviction was a significant economic penalty if a Black person tried to vote. And indeed, in the midst of the civil rights movement in 1960, 1,400 African Americans registered to vote in Fayette County, Tennessee. Half of them, 700 of them, were evicted from their sharecropper homes. White landowners in Greene County, Alabama, evicted at least 75 Black families that year, and more than 40 Black families were evicted in Lowndes County, Alabama at Christmas time, 1965. These evictions were part of a systematic plan to thwart civil rights activism and prevent Black people from voting. Black men and women who registered to vote were required to provide the names of their employers, who could then be notified that these Black employees were daring to try to vote. Newspapers printed the names of Black people who attempted to register, and white citizens' councils distributed voter lists to white merchants who would then deny basic necessities and employment to African Americans who registered or tried to register to vote. This is the 1960s. Many evicted families were forced to live in tent cities that sprang up throughout the South. In communities that most closely resembled refugee camps, entire families sheltered in fabric tents that froze in the winter with no running water and outhouses for dozens of people. Then white segregationist night riders would terrorize the camps, firing guns into the tent cities in the middle of the night, because we don't want those people to vote. Finally, the violence, the economic actions led Congress to appreciate that the resistance to the 15th Amendment right to vote was insufficient, and backed and enforced and accelerated by the civil rights movement, Congress passed the Voting Rights Act of 1965, which has been called the single most significant piece of civil rights legislation ever passed by the Congress of the United States. There were three key sections of the Voting Rights Act. Section 2 basically restated the 15th Amendment, that the right to vote shall not be abridged or denied on the basis of race, color, or condition of previous servitude. Section 4 created a formula for identifying jurisdictions that had a history of this horrific racial discrimination. They might be states, they might be counties, they might be municipalities, but there was a formula to determine those jurisdictions that had undertaken hugely significant and successful efforts to deny Black people the right to vote. And the Voting Rights Act said that Congress could update and rewrite that formula over time to determine what jurisdictions should be covered by this law. Because Section 5 of the law said that those targeted areas could not make any change to their voting laws, none, without getting pre-clearance from the Federal Department of Justice. What had happened before, it was against the law, it was unconstitutional, but states would write these laws and implement them, and then those who were disadvantaged had to file suit and had to work their way through the appeals court or try to get to the Supreme Court. In the meantime, these repressive voter suppression laws were in force. With the Voting Rights Act, it said, no, you can't put them into effect until you get clearance from the Department of Justice that they are not discriminatory. And so that preponderance of voter suppression laws came to a screeching halt in those jurisdictions. The law also provided that it had to be renewed every 5 years. And so in 1970, Congress voted again to renew the Voting Rights Act for another 5 years. In 1975, they said, didn't we just do this? And so they said, well, let's renew it for 7 years. And they updated Section 4, the formula that described the jurisdictions that needed to be covered. In 1982, when it came up again for renewal, Congress said, this is really silly. And they renewed it for 25 years. When it came back in 2006 for its next renewal, Congress overwhelmingly reauthorized the law for another 25 years. The vote was 390 to 33 in the House and unanimous in the Senate, if you can imagine such a thing. So from 2006, that would say the next renewal would be in 2031. But the Supreme Court stepped into the fray with a case called Shelby County v. Holder, Shelby County, Alabama, the Eric Holder, who was the Attorney General of the United States. And the Supreme Court, in its wisdom, struck down Section 4. It got rid of the formula for identifying the jurisdictions that needed to get pre-clearance. It was 9 states and counties and municipalities. And the justification offered by the Chief Justice was, we don't need to do this. We don't need to worry about these jurisdictions because They aren't passing these laws anymore. The fact that they weren't passing them because the Department of Justice, as described in Section 5, wouldn't let them, was somehow lost on the justices. And so the Voting Rights Act of 1965 was gutted in 2013. Within 8 hours, Texas instituted a previously blocked voter ID law. North Carolina reduced its early voting locations from 16 to 1. Alabama closed the DMV offices that grant photo IDs in 8 of the 10 counties where the Black population was greater than 75%, meaning you would have to go get your ID from another county. So between 1982 and 2006, the Department of Justice blocked 700 discriminatory voting changes, and that blockage process was gone, was removed. And so the assault on voting rights began in earnest, based on the myth of voter fraud. A Loyola University constitutional scholar did a study of all of the votes cast between 2000 and 2014. That was 1 billion votes. His name was Justin Levitt. I'm thinking he wasn't married. Anyway, he looked at 1 billion votes during that time period, and he determined that there were 36 instances where possibly a voter ID law might have prevented a vote. 36 out of 1 billion. But this idea of rampant voter fraud took hold, and states began passing laws ostensibly to prevent it. Some of the examples of those laws. The state of Alabama issues the government issues a photo ID to every person who lives in public housing. Those photo IDs are not valid to prove your identity in order to vote. You have to get another government-issued photo ID to vote. In the state of Georgia, they had 12 types of IDs that were valid, and they eliminated those. And they substituted 6 types of government-issued photo IDs that white people were likely to have and Black people were not. There was not a single driver's license bureau in the city of Atlanta if you needed to go to a DMV to get your ID. In Indiana, there had not been a single instance of voter fraud in the state's history, but they passed a law that said a birth certificate is required in order to get a driver's license or a state ID. Okay, but in Marion County, Indiana, home to 200,000 African Americans, you had to have a driver's license as proof of ID to get a copy of your birth certificate. In North Carolina, Governor McCrory focused on fraud. The North Carolina Board of Elections analyzed almost 5 million votes in 2016, and they found 1 vote that they think a voter ID might have prevented. The legislature did a study to gather information on what kinds of IDs are white people likely to have and what kind are Black people likely to have. And then they tailored the list that works as a voter ID to favor the white voters. The Fourth Circuit Court, when this was taken up on appeal, ruled that the law was targeted at African Americans with, quote, almost surgical precision. In North Dakota, the Supreme Court requires that your ID used to vote has a street address. Except if you are a Native American living on a reservation, there are no street addresses. You have a post office box. So your state ID as a Native American is not valid for you to use as proof of identification to vote. In Texas, 1/3 of the counties don't even have a Department of Motor Vehicles. In some cases, it requires a 250-mile round trip to go and get your photo ID. And the one I love about Texas is if you have a concealed carry permit, that's valid as a voter ID, but your student ID is not. States began doing illegal voter roll purges, and these continue. Literally millions of people have been removed from the voter rolls, sometimes ostensibly because they didn't vote in the last election, which is not justification for removal based on the National Voting Registration Act. And the state of Kansas created something called the cross-check program. And it said, you know, we think that there are millions of people who are registered to vote and are voting in two different states at the same time. And so they had this computer program, and it did a match on first and last name and date of birth. And you would think, well, you know, if there are two people with the same first and last name and date of birth in two different states, could very well be the same person. Except some of the states didn't capture date of birth. And so if your first and last name matched somebody in another state, you were suspect that you were attempting to vote in two states. And so one year, Iowa learned that there were 240,000 Iowa residents who, based on the cross-check program, were also registered to vote in another state. And they undertook a taxpayer-funded study to track those down, looked at the 240,000 names, and found that there were 6 people who were the same registered voter in Iowa and another state. But in every case, the individual had either moved from Iowa or to Iowa and had no intention of voting in 2 states at the same time. Minority precincts discrimination is enormous. States have reduced the number of sites for voting in predominantly minority areas. They've reduced the number of days that are available for voting, and also the resources that are available. And this showed up in particular in the 2000 election. You may recall Florida was kind of pivotal to the presidential election that year. Leading up to the 2000 election, the election control board was dismayed to learn that 16% of registered voters in Florida were Black, up from just 10% in 1996. And so the Florida officials devised a laptop program that could be available, letting election officials determine if someone was indeed registered to vote. And if someone came in, the election official could tap into the database in Tallahassee, discover that the person was registered, and let them vote. But the laptops were not given to the precincts that were majority African-American voters. There, a poll worker would have to try to get a phone call through to someone in Tallahassee to ask them to use the computer to look up the person's name to see if they were registered to vote. And so in Miami-Dade, Black votes were thrown out at 4 times the rate of white voters. In addition, remember the hanging chads? Some of you do, some may be too young. Those punch card systems were largely made available to majority minority precincts. The majority white precincts had electronic voting machines. And so all of that issue of looking at whose vote should and shouldn't count was in the minority precincts. Intimidation was a key feature, voter integrity agents would be stationed outside of polling places. And if an African American walked up, they would be told that even an innocent error in their registration might be cause for arrest. In some places, their photograph was even taken, so with the implication that they could be visited later and punished for violating the law. We know that there has been an issue about felon voting rights, and we certainly know the impact of the criminal justice system on the percentage of African Americans who have a criminal record. In Maine and Vermont, you never lose your right to vote. You can vote from prison. They have the polling stations in prisons. In 14 states and the District of Columbia, you lose your right to vote while you're incarcerated, but it's automatically restored when you're released from prison. So one of the things they tell you is you're released from prison, you are now eligible to vote. In 21 states, you lose your right to vote while you're incarcerated and typically while you're on parole or probation. But nobody necessarily tells you when your parole or probation is completed that you now have the right to vote. And in 13 states, you lose your right to vote indefinitely. In some states, it requires a governor's pardon of your crime in order for you to be able to regain your right to vote. And so there is a sizable population disenfranchised by those felon voting rights laws. We know that gerrymandering has had a huge effect on representation. Okay, people can vote, but for example, in Wisconsin state elections, the Democrats won 52% of the votes that led them to hold 39% of the seats. In the 2016 North Carolina election, Republicans received 50% of the votes that translated to 77% of the seats. And so the skewing of the gerrymandered districts has an enormous effect. It also means that there are safe seats. It doesn't matter what a candidate says or does. If they are of a particular party, they're going to win. And often the opposing party won't even put up a candidate. So how is this equitable? And then, of course, we have the effect of Citizens United and what that has meant for money in politics. And keep thinking it can't get worse, and lo and behold, it does. And so the 2020 elections had a huge impact on the assault on voting rights. And in fact, between 21 and 24, the blue states, the aqua states, all enacted restrictive voting laws. Lots of them are now focusing on your needing to provide proof of citizenship to be able to vote. You never used to have to provide your birth certificate to vote. You needed to show something with your address. Could be your driver's license. At one point, it could be your electric bill. In some states, it still can. But now there are states that are saying, no, you have to have a passport or a birth certificate. You have to prove that you're a citizen to be able to vote. Interestingly, a lot of these laws are attacking early voting and absentee voting. And the reality is, now 2020 was at the height of the COVID pandemic. There were 158 million votes cast for president that year, and 116 million of those were early and absentee. 85 million of them were in states that subsequently sought to limit the number of early and absentee votes, potentially having an enormous effect on who bothered to vote, who got out to vote, who participated. And after the 2022 election, the focus turned to targeting every stage of mail voting. There were states that used to send out a mail ballot to every citizen, and that stopped. Stricter voter IDs. States are making it much more difficult for voters with disabilities. They have changed polling places to non-ADA compliant sites. They have instituted laws that says someone cannot help you fill out your ballot if you're blind, if you're disabled. They've loosened the requirements to educate voters. So if you've been going to the same polling place forever, they change the location, but they don't have to tell you that they did. And you show up at your polling place and there's nobody home. And some of these laws are really undermining the electoral process itself. Citizen-initiated election audits, investigating and prosecuting voters. It's against the law to give a bottle of water to someone standing in a 3-hour line waiting to vote. My friend in South Carolina cannot drive his elderly neighbor to the polls anymore because they are not part of the same family unit. Civil and criminal penalties are being identified against election officials. And these election integrity functions and agencies are another form of intimidation. Professional election officials are being removed and replaced by partisan players. So what could help? A number of these need to be enacted on the federal level, but automatic voter registration, Delaware has that. When you turn 18, you are automatically registered to vote unless you ask not to be. The commissions that redistrict areas every 10 years should be independent, nonpartisan districts instead of that of the ruling party. How about making Election Day a national holiday? What is more citizen-like than voting? Make it a national holiday so that it's easier for people to get off from work to be able to vote, particularly as the hours for the polling places are starting to shrink. Enforce the National Voting Rights Act. Do not let agencies purge voter rolls just because someone didn't vote in the last election. And the John R. Lewis Voting Rights Act is the new 1965 Voting Rights Act. It would transform the landscape of this legislation. It has 0% chance of passing at present, but it too would be one of the most significant civil rights laws ever passed by Congress for that to happen.